All right, now let's talk about adverse possession. That's another one that has come up during the course of this trial that a lot of people have just scratched their heads and said, there is no such thing. It's illegal. You can't camp out on somebody else's property and acquire any kind of legitimate title to the property. They're making that stuff up. It's exactly the kind of thing that John Oliver would say. Is this still a thing? Adverse possession. What does it mean? Well, again, I'm going to try to take a simplified, nuts and bolts, nutshell, crash course approach to this. It is still such a thing. If attorneys that deal with real estate on a regular basis can tell you that it happens all across this country, out in the country, out in the rural areas, in the urban areas, in the city, it happens all the time. What it boils down to is this, and the basic concept, and again, look it up on Wikipedia. Look it up on Wikipedia. The requirements, the elements of adverse possession are that you have to take actual possession. You have to be there. You have to possess the property. You have to have a physical presence. It has to be adverse, hostile, non-permissive. So in other words, you don't have permission to be there. There's not some agreement or something like that. You are there without permission. And it's got to be open and notorious. It can't be secret. It can't be that you're going there at night and hanging out when nobody can see you and then leaving during the day. It's got to be open and notorious. It's got to be continuous, and it's got to be exclusive. And what that means is that you've got to control other people's access. Control of access is very important because it's got to be exclusive. There's also a concept called adverse use. Adverse use happens all the time across this country. It's the process by which prescriptive easements are acquired just by use. It's got many of the same elements. Actual use, hostile, non-permissive use. You don't have permission to cross somebody's property to get to your property. You're doing it openly and notoriously. You're doing it on a continuous basis. You're doing it for a period of time. All of these require that this happens over a period of time. That is how title can be acquired by adverse possession. In the state of Utah, where I live and practice law, we have a statute that governs adverse possession. It says that if you do all of the things that I've described, and in addition to that, if you pay the property taxes on that property, you can acquire title to that property after doing all of that for 7 years. So if you possess it, and if you keep everybody else out, you control access, you're doing it openly and notoriously, you pay taxes on it, you can acquire title to the property. You have to file a quiet title action to do that. And that's something I've done on a number of occasions, and they involve, whether it's boundary issues, sometimes that's what it boils down to. It doesn't involve an entire piece of property. Sometimes it involves just a portion of a piece of property where a fence is in the wrong place. The fence doesn't coincide with the actual property line. So there's a piece of property within the fence line that doesn't belong to the other person. But the person that is within that fence line occupies that property openly, notoriously. They do it adversely. There's no agreement between the parties. They do it for 7 years. And they can acquire title by adverse possession. Now, people have said, well, but you can't do that against government. And there's some truth to that, and that's what I've always thought too, because we've got this concept called sovereign immunity. There is no liability against the sovereign, the government, unless the government consents to waive its immunity. And so that is the popular misconception. Even if adverse possession is such a thing, even if you can do it in some situations, the popular misconception is you can't do it against government. But the reality is, you can do it against government under those circumstances where the government waives its immunity and says you can. And in this case, when it comes to adverse possession, there are a couple of instances where the government has said that it is willing to waive its sovereign immunity to allow people to acquire rights by adverse possession or adverse use. One of those is under RS 2477. It's the process by which ranchers and other users in the West acquired access rights across the federal land by doing that openly and notoriously for a period of time prior to 1976. the statute says that if you did that openly and notoriously, you had this 2-track that you were using to get to your ranch, to check your cows, to check your windmill, to go hunting, to go mining, to recreate, to go fishing. It doesn't matter what the use was. If it was used for a period of time, 10 years prior to 1976, and you can establish that use, you can acquire a vested right to continue that use against the sovereign, against the federal government. Well, the federal government did the same thing under Section 43 USC 1068. It set up a statute that said under these limited circumstances, you can acquire not just an adverse use right, but you can acquire right, title, actual title to the property by adverse possession. You've got to meet all the requirements. There's a period of time involved. You've got to be able to trace the possession with all the other requirements: adverse, notorious, open, continuous use for a period of time. That statute actually says that it had to be started before 1901. And so at this point in time, obviously, in order to do that, you've got to go back and establish that possession through predecessors in interest. And a lot of people have said, well, so that's it. Ammon Bundy, there's no way that he could acquire adverse possession to the refuge. And I'm not arguing that he could. Attorney Mike Arnold said the only way that that would have worked for him was if he had been able to come up with a time machine. And I think that there is some legitimacy to that observation. But the point I'm addressing is this: to all those people who say that adverse possession isn't such a thing, you can't do it. It is such a thing. It happens all the time, and you can do it against the federal government conceptually. If you and your predecessors in interest had continuous possession of a piece of property that the federal government had title to, had ownership of, and you had done that in good faith, and all your predecessors in interest had done that, and there are plenty of examples where that actually happens. In the area where I live, it happens all the time with private property. Granted, I live out in the country. I live in ranch country. I live in agricultural country. There are absentee owners in this neck of the woods. People who own the property never use it. Sometimes they tell people, you can use my property if you'll just pay the taxes. I don't care if you do anything else. Just pay the property taxes and you're welcome to use it. You're welcome to put it to beneficial use. In other situations, people just use it. They graze it. They put it to beneficial use, whether they have permission or not. Now, so people say, well, that doesn't and it can't happen in the city. And the point that I want to make is that it happens in the cities all the time, especially during this last recession with all the foreclosures that occurred of houses. There were banks that acquired whole portfolios of properties, residential properties. And in a lot of situations, people did go and they squatted in those houses. They took adverse possession of the houses. They broke in. They did it openly and notoriously. In fact, finally, a law was passed in 2012 that says it's a criminal offense to squat in a house like that. But this is the interesting part. And if you don't believe me, look it up on Wikipedia. Even despite the fact that it's a criminal offense to squat in a house like that, you can still acquire title to a house like that, a residential property, by adverse possession if you meet all the other requirements. And I can tell you, I can assure you, just because you've never seen it, just because you haven't been exposed to it, doesn't mean that it hasn't happened over and over again in this country. It happens all the time, and it's happened recently in the last 10 years on a number of occasions. So, adverse possession is a real thing. It's not just something made up. It exists. It's a sound legal principle. It was a stretch potentially at the Malheur National Wildlife Refuge, but even the federal government has spelled out in statute terms under which it's willing to waive its right to sovereign immunity and allow people to make legitimate adverse possession claims against the federal government. Now, then it becomes a factual question of whether or not that actually occurred. That isn't the issue that was on trial. But there have been plenty of people saying that it just cannot be done. There's no legal way to do it. And so we're trying to diffuse and debunk that popular misconception. It can be done. We'll leave it at that.